Hello, and thank you for joining us today on our webinar. The topic today is, are you ready for the H-1B CAP season? Today we have Jake Lippman with us from INSZoom, who will be providing this training webinar to you. Good morning, Jake.
Good morning. I'm excited to be here and looking forward to this time with all the attendees.
Great. Very nice.
Yep. Go ahead.
That is very nice. We appreciate you working with us on these webinars and providing the information to others.
You're welcome. Well, I'll just jump in and start going. I'll lay down some of the ground rules and things that are going to happen here. First of all, you'll have the GoToWebinar control panel where you can ask questions. I think that would be great if you want to ask questions. I won't probably be able to get to those during the webinar, but afterwards I'll do my best to answer the questions that you post. And if I can't get to the questions during the time that we have available, which I'm going to probably shoot for about 45 minutes to an hour, but if there's not enough time to answer your question on the call here, then we'll answer in writing afterwards. These results will be sent out to the attendees, as well as the slides from the presentation, so that you can review them or kind of go back and think about this again in the future. Hopefully it will be useful to you. As Kristen mentioned, trying to get my slides right here. I'm Jake Lippman. I've been in practice in the area of mostly business immigration for over 15 years. My practice is out here in California. The weather's great today. And I've had a lot of experience with H-1B CAP. I've had some great experiences. I've had a couple bad ones, and so I do speak from a position of experience in this area. So I think that hopefully I can share some things that will help you avoid the kinds of issues that might come up, and maybe even take advantage of some opportunities that are related to this particular season. This is a kind of a repeat broadcast of the webinar, the same topic we did maybe a month ago, because really the idea is to get a timely start on the whole H-1B CAP experience. But even if you're a little late to the party, don't worry. This information is going to help you. One of the first things I want to do is just get a sense for the audience and the level of experience that you have in this kind of particular area, H-1B visas and whatnot. So I'm going to put out a kind of a little poll for you to respond to, if you wouldn't mind. Maybe you can post your level of experience in the H-1B CAP and where you feel you stand. Feel free. You don't have to be too humble here. I'm just curious what you actually think, or where you really are in your kind of where you are in your career path at this point. And it tells me a little bit about how I want to address things and the level of knowledge, so that I know how to build a foundation on the topic as we go through this. All right, great. Looks like most of you have actually voted, and that's helpful. I want to share those results here so you can see that majority are beginners here. You got a group of people that feel they're intermediate. Almost 90% are somewhere in the beginner to intermediate, and then a few advanced. So the kinds of questions that you ask, I know there's going to be some variety there. Please post questions. Help me to know how this can be a better presentation. Oh, and another thing, we want to do more presentations going forward. So if you wanted to provide feedback, you could send an email to Kristen about the kinds of things you'd like to hear about going forward, maybe in a future webinar, or something you liked or didn't like. It's helpful to get that feedback so that we can do a better job in giving you the information that you need. All right, so let's kind of move forward. Basically, the outline, I'm going to introduce the topic. I want to talk about why you want to be ready now for the H-1B CAP, as early as possible, or maybe yesterday or last month to be ready. The kind of common mistakes people make and how to avoid them, how to use your technology if you have INSZoom or a case management system, how those things can be leveraged to help you in the CAP. Talking about the different H-1B candidates and how to assess them, and then post-filing issues. So hopefully this will cover most of the things that come up during a CAP season. So let's kind of go through an introduction here. From the most basic, like I said, there's quite a few of you are beginners. So let's start at the beginning. The H-1B is a quota. It's the number of H-1Bs that are issued in a given federal fiscal year. The fiscal year for the government starts October 1st. It's like Happy New Year, Uncle Sam, October 1st. All right? On October 1st, 65,000 new H-1B visa workers are going to start with their employment. They can begin working on October 1st. So within that 65,000, there are some H-1B workers that will be exempt from that quota. It's important to look at that. Most of you probably won't have these kinds of organizations if you're just getting started, but you know, universities, certain kinds of nonprofit research institutions, and government entities, they are typically exempt from the cap. So if you're having some kind of question, maybe a school district or something, it seems like a government, that should raise a flag. Maybe there's a way for you to exempt a particular person from the 65,000 quota. There's an additional 20,000 H-1Bs for individuals who hold an advanced degree from a U.S. institution of higher learning. In the federal regulations, a U.S. institution of higher learning is defined as a school that is not a for-profit institution. So you want to look at that, because people will come and say, oh, but I have a master's degree here, I should be in the 20,000. They're not going to be in the 20,000 if it's a for-profit a university. So look for that. And also make sure that the advanced degree is in the specialty field that is required for the H-1B. Those will be things to help you out so you don't make kind of, you know, those things can come back and bite you later. So basically, the earliest possible filing date to obtain the H-1B that will become active October 1st is 180 days before October 1st. It's about 6 months. Happens to fall on April 1st. Fool's Day, but I'm sure there's no correlation there. That wasn't intended. This year it happens to be on a Friday, and the government will accept all the H-1B petitions that are filed during the first 5 days of April. They're going to collect all the petitions that are filed the first 5 business days. So that'll be through April 7th, which is a Thursday. So you've got some time. There's some kind of rumors, or you'll hear superstitious people say, oh, but you've got to file on the very first day. It's probably a good idea to try and file on the first day just so you know everything is ready to go, but it's not required. And I would say take your time. If you're, you know, don't run too loose or roughshod over this process, just to file on April 1st, because you can file on the, you know, the first 5 business days. Keep that in mind. Now, last year, in the fiscal year for 2016, there were 233,000 H-1B petitions filed for 85,000 total available. That's just, it's just really, really tough to get an H-1B. Even several of my clients that had master's degree, the higher education people, were not selected in the CAP last year, and it was, you know, it's really frustrating. This year, I want to pull you, maybe some of you, the more advanced and intermediate especially, or others who've been kind of monitoring the situation. I'm going to put out another question to you. What do you think it's going to be this year? Is it going to be, you know, significantly less than last year, maybe a little less, somewhat more, about the same as last year, and so on? Feel free to share your thoughts about what you feel it's going to be based on your own experience. I think this is going to be useful information for everybody to see. I'm going to let it go for a couple more seconds because there's still a few of you voting. All right. I think this kind of captures the idea. So let me close the poll real quick and show you what that looks like. So nobody thinks it's going to be less than last year. most are kind of somewhere maybe a little more than last year. Some are saying significantly more, and others similar to last year. So I'm kind of hoping that it's at least similar. One of the things that makes me think that it could possibly be a little bit better than last year is that the government came out with that 50-50 rule again, where the companies with more than 50 employees and have more than 50% of the headcount as H-1B or L-1 workers are going to pay a $4,000 surcharge on top of all the other expensive fees that go with the H-1B visa. Obviously, this may have an impact on some of the big filers of H-1B visas. I'm thinking it could. I'm hoping it does in a certain way, even though I kind of resent the whole $4,000 thing. I think that's they should just increase the numbers is what they should do, but here they've created kind of a disincentive to these larger companies, and so that could create opportunities for some of the other businesses that are trying to get an H-1B but are daunted by the whole numbers problem that we see. So the way it works, the first lottery, okay, they're going to give to the 20,000 individuals with advanced degrees. So that's the very first group to be selected. So those will be all grouped together. 20,000 will be pulled out. Of those, if they are not selected for H-1B processing, then they will be kicked down to the 65,000 group and allowed to get another chance to be selected in the H-1B lottery. It's like getting a second bite at the apple. So these guys with masters or other advanced degrees are really in a much better position. And again, that has to be from a U.S. institution of higher learning. So why do you want to be ready now or a month ago, a couple months ago? All right, it's never too early to start thinking about H-1B cap. It's something you really want to be considering all year round as you take on new cases, as you look at the clients you're working with. You always want to consider which of the people that are in their system are, may need an H-1B, and be on the lookout for those as the year goes around. It's a business development opportunity. Many of the companies that do the H-1Bs, or several of them, means that they do, especially companies that do a large number of H-1Bs, are looking at their vendors early in the process. They're not going to come into this in January or February, or certainly not March. They're going to be looking at vendors who, law firms who can handle the volume, who can handle have the expertise and so on early in the process, maybe even months before the new year. So that's something to think about. Also, another thing you want to do is to make strategic plans for the different H-1B candidates that you have in your client base. Some of them may have max out dates for the different kinds of visas that they hold, or maybe they need to be considered for permanent residence, and part of that permanent residence strategy we'll talk about in a little while. But that's something you want to think about, because H-1B generally is one of the better tools that you have to lead someone to the green card if they happen to be in some other non-immigrant visa category that doesn't really lend itself to the permanent residence process. I haven't seen a lot of questions yet, so feel free, post your questions. I'm looking forward to those. Maybe we'll be able to answer some of those a little bit later, hopefully. So, common mistakes and how to avoid them. Okay, we talked about this a second ago. Start early. Obviously, I can't overemphasize this idea, but begin reminding your clients early and then through the H-1B season that this is coming, that the season is on, and now you need to know all their candidates and anybody that you haven't already considered for H-1B visas. Okay, you want to have a nice structured process as you prepare your H-1B visa petitions. This is really critical. It's been something I've noticed over the years that there are certain parts of the H-1B petition where if you make a mistake, the petition will get sent back to you, or it will get automatically denied for some technical reason. These things you obviously never want to happen. It would be the biggest waste for your client to spend all the money and cross their fingers and hope for a number or to be picked out of the lottery, and that opportunity is wasted because you've made a basic kind of, a mistake. One of those things would be to make sure that you've addressed the petition to the proper service center. This seems like a no-brainer, but I'm talking to a lot of beginners here. So at the very outset of your engagement with the client, when you start to do the H-1B, it's probably useful for you to have a spreadsheet or something that you're going to keep track of all these different CAP cases and indicate which ones are going to go to the California Service Center based on the location where the work is to be done, or which ones are going to go to Vermont. This is something you definitely want to identify early, and just make sure that they don't get mixed up, because that would be a super blunder if you sent it to the wrong service center. And you wouldn't be the first person to do it, I guarantee you. Out of 233,000, you can guess there's going to be a bunch of people that accidentally do that. Don't be one of them. Another one is that you need to make sure it's addressed in the proper way as a master's or a bachelor's cap, a regular cap case. There could be a difference, and there has been in previous years, of where you are to send the petition based on the type, if it's a master's or bachelor's. That is something you obviously want to check as well to make sure that you have looked on the latest version of the USCIS website to make sure that you're sending it to the right address based on their current instructions. Another thing is to make sure if the client wants premium processing, you've sent it the right way and packaged it properly for that. Again, these are no-brainers, folks, but trust me, you wouldn't be the first person to blow it. Properly signed forms, I think that means to say, and checks, right? Everything has to be signed in the right way by the client and by you as the attorney in the different parts of the forms. So another thing that you need to do is make sure that you have your LCA, the labor condition application with the U.S. Department of Labor. Those should be filed as soon as possible. Earlier the better. Identify the prevailing wages, get those on file. Doing it at the last minute is very risky because sometimes Department of Labor will have hiccups with their technology system. These are to be filed online, and you can have problems, delays, and get into trouble when Department of Labor is somehow backlogged or their system is having problems. You could be the person who's sitting there trying to hope you're not going to get shut out of the whole game because you weren't able to get an LCA approved in time. One more thing I think we could add to this is that you have the most current version of the form that's required. Sometimes you have an old G28 or you have an old, maybe the I-129 or something like that. Make sure that the version you have is the latest version because you just want to be careful. One example could be maybe you filed for somebody last year, you kept the petition, you think you're just going to send it in without really reviewing it again. Be careful, folks. You want to review and make sure that you've still got the most current version of the form, or redo and take whatever measures are necessary to ensure that you've got the most current issued form. So here's how we can use technology to help the situation. I just talked about the form changes. There was probably like 6 or 7 years ago, man, it might have even been more than that, but time's flying here. There were several changes to the form I-129 within like a few days from the time that the cap was going to come out, like right before end of March kind of thing, middle up to end of March. They changed the form like 3 or 4 times, all in succession, and people were totally freaking out. Nobody knew whether USCIS would accept the earlier version of the form that their clients had already signed, and all of this, they'd been preparing for months to do the cap. Everybody was panicking. It was total chaos. But one of the nice things was that INSZoom had the form prepared and ready each iteration, each version that came out, the INSZoom system had the new form within like hours, not days, not even like, the next day. It was like the same day kind of thing. And so that was really a big deal for the practitioners because everybody was, trying to get that new form and get their client to sign it and didn't really know what the repercussions would be if they couldn't get it done in time. So they definitely didn't want to be sitting around waiting for their technology provider to get that thing on the system. So that was a really, that was a time when it was really important to have a good technology and that the system was able to help. Another thing that, and that may happen again, by the way. I've heard rumors that they may try to change the I-129. Don't be surprised if it's sometime in the next month or two while we're all trying to get ready for this cap. That's kind of the thing they might do out there. Knowledge base. Knowledge base is basically all the things that you need to prepare the H-1B petitions. And within the INSZoom software application, you find these tools in this area, knowledge base. That's what it's called. You got your letter templates and questionnaires that are online for the client to fill out, document checklists that tell the clients what they need to provide to you. You've got the steps and reminders, what to do and how to follow, so your team, or at least you know what to do along the way. And then you may have some deadlines or alerts to keep track of things that you don't want to miss. All of those tools, if you have developed them before the cap, are going to be a huge asset to you during the cap while you're trying to produce a lot of work in a short amount of time. Okay, so it really pays to invest in this knowledge base and build it out so that you've got that, all those templates ready to go and everything is dialed so that the, you open case after case after case and you can really produce quite a bit more work with fewer resources. One of the last things that your technology, I want to mention, should be able to do for you is to give some kind of reporting or sorting so that you can pull out data and see who are the cap cases that you're trying to work on, make sure nobody's going unnoticed or nothing's falling through the cracks. You can also look at your numbers and statistics and figure out maybe for the next cap some trends or other kinds of things that will help you to avoid situations that you may have encountered. Or to find new opportunities and figure out what's going to work better and how you can get more business. So these things can really help you take advantage in the cap using your technology. So one more thing, assessing your H-1B candidates. This is really probably the, at the basic level of the whole H-1B cap is figuring out who needs an H-1B visa. Certainly, it's the new hire from abroad, right? Your company, your client is saying, we want to hire some person from India to come and do software development. That seems like it's probably the vast majority of the cases that you're going to work with. That's a common situation. They want to bring a new person who's never been to the U.S. But another one is the F1 student who's maybe working for the company under an OPT program, the Optional Practical Training arm of the student visa program. Those people may have joined your employer client somewhere in the last year or two, but you would never know about it because they got that work permit through their university and they never bothered to tell you. So these are people who are flying under the radar as far as you're concerned. It's really important for you to touch bases with the client to figure out, are there any of these people sitting in their organization that need an H-1B visa? If they are there, then of course you want to bring up the issue and say, hey, this person would probably need an H-1B visa to continue working. We need to get that going. Probably the individual would have brought it up to the employer already. Hard to say, but those kinds of things you just really never want to miss. And sometimes if you haven't mentioned it to the client, it will go unnoticed. They don't always know to do these things, and sometimes the student, that individual worker could be a little slow on the uptake, doesn't know about H-1B. That's unusual, but it does happen occasionally, and those are the guys you don't want to fall through the cracks. Another thing that we mentioned earlier that you need to consider is the long-term planning for certain other workers that hold different categories of non-immigrant visas. Let's talk about the L1 as an example. The L1B has a 5-year limit on the period that they can stay in the U.S. under that particular status, and L1A is a 7-year period. H1B has a 6-year limit. However, 6-year limit can be extended beyond the 6 years if that person is in a green card process. Okay. For the L1s, there is no similar provision, so at the 5 or 7 years, they're done. And if you haven't already done something for them, if that client hasn't already done something to get them a green card, then they're done. So turning to H1B, converting, especially for the 5-year L1B worker, will take them into the 6th year and give them a vehicle to go beyond even the 6 years with a green card process pending. So that's something that has to be raised or should be raised probably early in the L1 workers' tenure at the company. They need to be considered for H1B. At least the issue should be raised. Now the next thing, the TN, the E3, the E2, or H1B1, which are workers from Singapore or Chile. These people, they have a work permit. They're able to stay in the U.S. However, these particular categories have a non-immigrant intent provision, which means that they are not to apply for green card without some kind of possible consequences. That needs to be navigated very carefully. There could be some way to convert these people to green card without considering them for H1B, but generally this should be raised. This issue needs to be considered because changing them to H1B will give them the ability to have immigrant intent and pursue a green card while they work for the company, whereas most practitioners probably would advise against trying to pursue green card for someone in the TN, E3, or these other categories. Like I said, there are exceptions that needs to be handled kind of carefully, but converting to H1B is a surefire way to put that person in a position to pursue green card, and so it should definitely be looked at. One more thing that I've seen come up various times, people looking into hiring a worker, maybe on a student status or some other kind of situation. I've seen this a couple of times. Maybe nobody bothered to consider that that individual had had an H-1B visa before. Something I don't think I mentioned earlier, or maybe I touched on briefly, was that this whole H-1B cap thing is for new H-1B workers. Okay? It's not for the people that are already here on an H-1B that were selected under a previous quota. This may seem obvious, I know, to many of you, but for a beginner, only the new H-1B visas are under the 65 and the 20,000 that we talked about, 65,000 and 20,000. It's only for the new H-1B workers. People that were already selected in previous year's quotas, they can renew their visas as long as they are allowed to up to the 6 years and beyond, and they don't need to be counted under a quota ever again. So the question comes up, if there's a new hire in a company, there should always be asked if this person has held an H-1B visa before, or at least that should be something you think about. If you know for sure it's never happened, great. But I've seen at least 1 or 2 times where that person had an H-1B visa before, maybe several years before, but it wasn't mentioned, and then that came out later, and it could have prevented a whole lot of other problems and issues. Because if they have held the H-1B visa before, you can bring them back and extend their H-1B status, put them back into a position where they can work under the H-1B again, without being part of the quota, this whole cap, and all the stuff we're trying to talk about right now. Okay. Let's talk about after your H-1B visas are filed. Okay. So everything's good. You made the April 1st deadline, or you were somewhere in that first week of April. Everything was sent to the right place. Now what? Okay. Something you always want to do is remember to set those expectations with your clients. I think it's really important not to overpromise with the H-1B cap. Okay. I'm very fast to tell clients, look, there were 233,000 last year for 85,000 possible. It means you've got like a 1/4 chance. If you have a master's, it might be higher, but I'm not a statistician, so I can't really tell you what the probability is, but it's not, it's not stellar. So going into it, if they know that, they're already going to be in a much better attitude if things don't go as hoped. So remember to set that expectation. It's very, very important. Another thing are the timelines. They want to know, when am I going to find out? So the minute you file the H-1B, they want to know where they picked. So you want to let them know ahead of time, hey, when I find out, I'm going to let you know, and it's probably going to be within the first, maybe tell them it's going to be 3 to 4 weeks before you're going to know. All right? If you tell them it's 1 to 2 weeks, well, they're going to be bugging you after a week. These are just basic practitioner lessons that you pick up over the years, but it saves you so much grief when these people are not upset coming back to you asking questions over and over that you might have prevented by letting them know ahead of time and setting their expectation. Sometimes the client says, well, do we need the premium processing? You know, it's nice because you'll find out a lot sooner whether the H-1B was selected for processing, and you'll find out whether it was approved, but it doesn't really increase the chance of the case being selected in the first place, and so I'm not really sure it gives any, any real substantive advantage. With that said, like I said, it's nice to have that. On the downside, I don't like giving USCIS an extra $1,225 for doing something they should just be doing anyway. That's how I feel about it. That's my personal kind of issue with that. But clients are going to want it. You may do it. But again, setting that expectation is important. Another thing about after a case is rejected, the government fees are returned to you, so you can send them back to the client. They've only paid your legal fees at that point. That's the big loss. But they get their government fees in return. These cases, and many times, the first few weeks, maybe 2 or 3 weeks, you're starting to get the notifications of which cases have been received. The receipts are coming in. And then there will be a period kind of almost darkness where some of those have not been selected and you're not sure, maybe they're going to get picked up in the last part of the lottery, the last little fine-tuning as the government goes through with a fine-tooth comb and counts all the numbers. So you don't really know for sure they are rejected until you actually get the file back from immigration with the checks and everything else. So I think it's good to just kind of keep the clients posted saying, we haven't received anything, maybe on a weekly basis after the bulk of them come back. Hey, we haven't received anything. We're going to let you know as soon as we do. At this point, you're not rejected, but it doesn't look good. But there's still a possibility, so don't give up total hope. Okay, another post-filing issue, work authorization. Okay, so if that individual had another type of non-immigrant visa that allows employment like the TN or E3, H-1B1 that we mentioned earlier, while they're waiting for their H-1B change of status or for the new H-1B to be selected and approved, they are allowed to continue working under their valid non-immigrant status. They have to continue with validity. It needs to be current, but they can continue working while the H-1 is pending. The other group that is important and has a lot of little nuances to consider are the student visa holders who hold the work permit under OPT. Okay? Here are the things to know. If H-1B change of status is filed while the OPT is valid, OPT continues. All right? So if that person has an OPT that would be expiring somewhere in the middle of April or May or June or whatever, and you file for the H-1B visa before it has expired, then their work authorization continues. If they are not selected in the CAP, that work authorization will expire on June 1st. Okay? If they are selected in the CAP, then the work authorization will continue through September 30th. October 1st, the new H-1B becomes active, and so they are able to work and continue as an H-1B worker from October 1st onward. All right? But if you reach September 30 and the H-1B is not yet approved, that person is not supposed to continue working under the OPT status. They have not been approved for H-1B either. So now they're in limbo, and you're in a tough situation. One thing to consider somewhere before that October 1st would be premium processing and maybe trying to get that case approved before the October 1st deadline, just to move things up and so you can get the approval in hand and the person can continue working. That's another thing that you might want to start setting expectations earlier in the process so that you don't come to them at the last minute saying, hey, we need to do premium processing here, and get everyone all worked up. Stressful. Okay. One more issue is if the H-1B change of status is filed during the 60-day grace period of F1 status, then they can continue to be in the U.S. as a student visa holder, but they don't have work authorization. So if the OPT has expired, or if they're as a student, you have filed the H-1B at the time that their work permit was not current, now they can stay in the U.S. during the change of status process, but they will not be able to work. All right. Travel. Whoa, this gets kind of complicated, but don't worry. I think we've got the answers here. Generally, for all the people who have other non-immigrant categories like TN, E3, H1B1 for Singapore and Chile citizens, they can travel during the H-1B cap after you have filed the H-1B. But if you have requested change of status, which means if you have asked the government to change their status automatically from TN to H-1B on October 1st, if they travel before October 1st, they will interrupt that change of status request. The petition will not be abandoned, the government will not deny it, but they will deny the change of status component of the petition, and they will say, in order to activate that H-1B after October 1st, this person will need to travel outside the U.S., obtain a visa, and come back in. And only then are they to become an H-1B worker. So they need to be aware if they leave the U.S. during that period between April and October that there may be consequences to their H-1B status and that they're not going to automatically become an H-1B worker on October 1st. Again, these are important things to know to avoid problems. Another thing is the people who have the OPT status, the student visa individuals, the government has said that they can travel and not abandon their change of status request. However, if they do travel, they must have a valid EAD, which is the employment authorization document. It's a card that they have to show they can work. They need a valid F1 visa in their passport. They need a current I-20 from the school, a letter from their employer, and a valid passport, of course. So if they have all these ingredients, they should be allowed back to the U.S., and there should be a change of status permitted. But nothing is guaranteed with USCIS. I would warn such an individual that traveling does expose them to some kind of possible problems, and that they should consider, that in their decision about whether they want to travel or not, and that it could affect their change of status down the road. Those are the things I would look at post-filing. So I think we've kind of covered the gambit of most of the issues that you're ever going to see in an H-1B cap season. I'm sure there's other things that can come up, but I tried to figure out or think about the things that I've seen, issues that I might be able to help you with as you're trying to come up and learn. And so I just really want to say thanks to everybody for attending and for your attention during this presentation. It's been fun. I always like to do this. I enjoy the opportunity to share with colleagues, and I hope it's useful to you. In the future, as I mentioned, if you want to post questions about the things that, any concerns, if you want to put them in the GoToWebinar control panel there, I will do my best to answer your questions. If you have some thoughts about, how this could have been better, that would be great for you to post as well. Or if you have ideas on future subjects that we could consider for webinars, I'd also like to know about that, because I'm sure there are others who would benefit, and it's just something we can do to help each other out. All right.
Excellent. I do think we have some questions, Jake.
Okay.
in here. Can you see them, or do you need me to?
Yeah. Oh, I can see them now. Thank you.
Oh, you're welcome.
Oh, and I see them coming. This is great. So, first question, and again, I remember there's beginners, there's all types of people sitting on this webinar, so I'm entertaining all of them. One question, is it okay to mail the application by overnight on March 31st so that it arrives on April 1st? Yes. Okay, that is the way you want to do it. You definitely don't want to send it so it arrives on March 31st or some other day before April 1st. It needs to arrive on April 1st or someday during the first 5 business days of April. Not after, not before. Okay? Question, how do you know what service center to use? Okay? On the USCIS website, there is a filing instructions link that sits on the page for the I-129 form. So go to the forms page of the USCIS website, find the I-129, look for the direct filing instructions, and it will tell you state by state which service center you need to file at based on where the work will be performed. Okay? It can sometimes be that you need to look at where the company is headquartered. There are some variations in where you want to file. Generally, it's where the work is going to be performed, actually done. So look at that. Those are things, there are some nuances about where you can file depending on the company's location and things like that. So those are, you want to look at that a little more carefully, but you're not going to go wrong filing where the work is to be done. Where did the June 1st date come from? With OPT, if you look at the regulations for this cap-gap issue, if the H-1B is not selected for processing, they are not supposed to work past June 1st. It's in the regulation for cap-gap. At least that's my reference for it. Can't cite a reference right now, but have a look at that one. That's where you want to warn people they need to stop working by a certain date if they're not selected for the H-1B. What is cap-gap? Okay, so cap-gap is basically when a person has a work permit like the OPT for student visa holders, and it's going to expire sometime before October 1st when the new H-1B would start. So if I am a student visa holder that got the work permit after my degree program, and I go to work for your company, let's say it's going to expire in June, maybe June 15th, okay? If I file for my H-1B on April 1st, I'm not going to be able to work under the H-1B until October 1st because that's when the new H-1Bs are given out. So what's going to happen between June 15th and October 1st? Am I going to be able to work? Well, that's what the government provides in this thing called cap-gap, where if you filed the H-1B during the period your work permit was valid as a student visa holder, then you will be allowed to work from the time that your OPT, that's your work permit, expires until the H-1B is active on October 1st. So that's what they call cap-gap. Okay? All right. Some good questions. Some I can't really understand, so don't, I'll try to answer them in writing. Let's see. Can the beneficiary still keep the OPT status if the H-1B gets denied? The answer to that is yes. So if a person holds a different non-immigrant status, like the TN or E3 or student visa with OPT work authorization, and the H-1B is either not selected or is denied for some reason, then yes, that individual will be able to continue working under their valid non-immigrant status under a different category, which is good. It's their kind of plan B in case the H-1B does not work out. Oh, not cap-gap. You're looking for cap. I'm not sure. I'll need more information, Geeta, to answer that question. I'm not really sure myself. I'll have to look into that. So let's see. Any more questions? Anyone else wants to post a thought? Something I can answer. Needs to be a little bit so I can read it real quick while we're talking. And I think for now, some of these I'm going to have to answer offline because they're a little. I'm going to have to put it together and form an answer for a few of these. So like I said, appreciate your thoughts and would like to invite you to post other feedback or suggestions for future webinars that we can have. And thank you very much for your time. I'll look forward to being back with you in a future experience just like this one.
Great. Thank you, Jake. And thank everybody for joining us today. I'll send out the presentation to you this afternoon. Have a good day.